Hello. Um, if you are wondering what this video is, as you probably should be, because this is like super random. But yeah, so I've recently been creating a lot of stuff, personally, and I've been doing like little models, art, designs, patterns, all kinds of cool stuff. Some of which I've released, some of which I haven't released, and I'm not very savvy, I'll admit, when it comes to the business stuff and also the legal stuff. And being an independent artist, a lot of that stuff is a little bit mystifying to me. And I know we have the internet and Google, and we can learn and we can, you know, pay for all these things that will tell us how to do this or do it for us. And I think that's cool, but I think that, we have to remember that everyone has their own personal bias and their own reasons why, um, they're showing you what they're showing you. But I think it's important to like go straight to the horse's mouth or straight to the source to kind of get the information at its base level, and then you can kind of take it from there. And I've never been to the copyright website before, or the US Copyright Office website. And I think, they offer a lot of resources and cool stuff. And I think anyone that's a creative or anyone that has a cool idea or something that they think is original that they think they should, you know, protect or at least just like kind of put in a safer spot than maybe just that um, raw idea. I think this is what this is for. So let me see if I can chat. Can I do the chat? Sir. Okay. Someone's chatting with me. I don't know how to what. Okay, I don't. Okay, I don't know. I'm still kind of learning streaming and all that. Okay, so before I put you to sleep, let me figure this out. And again, just to like recap, I haven't been to this website before, so you are seeing me kind of go at it from scratch. And I'm not going to try and see how far I get today. I'm just going to kind of read the page, and then just kind of talk it through. So let's set a timer for 30 minutes. And, you're learning from someone who doesn't know anything, so keep that in mind, right? As you're watching this. It's kind of like learning by doing rather than, me being a skilled instructor teaching you. And I'm not being paid by anyone, and I'm not a representative of the US Copyright Office. I am not a lawyer, and I'm not trying to sell you anything. But if you would like to check out my website or anything, that'd be sweet. I just released a new character, so this is probably what prompted all this. Okay, so let's start. Okay. So yeah, here, www.copyright.gov. Um, oh, I didn't know you can go into DC and do on-site stuff. That's kind of cool. Well, that's near me. I should just walk over. Okay. So what is a copyright? Let's learn the basics, or learn about the basics of copyright with our new online reference page. Okay, let's learn more. Yeah, and I think, something that I thought of, and maybe it's like performance art, I don't know, but I think I'm just gonna like read this page in its entirety, that way, like, there's a video, at least of me, reading this and, you know, um, saying it in my own words. And I mean, I'm not going to read it just like, maybe I'll just like read a paragraph and then kind of recap or something. I don't know. This is live, so I apologize if it's a little weird. Um, okay, so copyright is a type of intellectual property that protects original works of authorship as soon as an author fixes the work in a tangible form of expression. In copyright law, there are a lot of different types of works, including paintings, photographs, illustrations, musical compositions, sound recordings, computer programs, books, poems, blog posts, movies, architectural works, plays, and so much more. Okay, very cool. And I like the paint brushes and stuff. That's kind of, I was painting the day, so that's sick. Fixes. This is probably when you see these bold things, they usually tie to some sort of legal outline somewhere, or there's a document or some sort of law or something where this verbiage is used, is my assumption. I'm not a lawyer, but it makes sense why it might be bold, because the definition of fixes and definitions of tangible forms of expression and definitions of original works of authorship will probably be outlined in some law somewhere. So okay, let's keep it going here. Copyright is originality and fixation. Original works. Works are original when they are independently created by a human author and have a minimal degree of creativity. Independent creation simply means that you create it yourself without copying. The Supreme Court has said that to be creative, a work must have a spark and a modicum of creativity. There are some things, however, that are not creative, like titles, names, short phrases, and slogans. Familiar symbols or designs, mere variations of typographic ornamentation, lettering, or coloring. This is an interesting one, since I made my own font in the last video. Might have to look into that. Lettering or coloring. Let me just start that back over. There are some things, however, that are not creative, like titles, names, short phrases, and slogans. Familiar symbols or designs, mere variations of typographic ornamentation, lettering, or coloring, and mere listings of ingredients or contents. And always keep in mind that copyright protects expression and never ideas, procedures, methods, systems, processes, concepts, principles, or discoveries. Okay, so I think, and I know a little bit about patents, not a lot though, but I think these type of things like ideas, procedures, and all this stuff is patents, which I might cover that in another video, but I don't think I'm in a spot right now where I'm going to be making a patent soon, maybe, but I think copyright would come before patent, at least for what I'm doing. Okay, so original works and fixed works. So these again probably are tied to some sort of verbiage um, within some law. Okay, so a work is fixed when it is captured either by or under the authority of an author in a sufficiently permanent medium such that the work can be perceived, reproduced, or communicated for more than a short time. For example, a work is fixed when you write it down or record it. Okay, super cool. Um, nice. So write it down, record it. If you have something cool, don't just keep it in your head, I guess is what it's trying to say, which goes good with what I like to do. If you have an idea, just get it out, even if it looks ugly. And if it looks ugly, at least it's an ugly fixed work. You know what I mean? Okay. Who is a copyright owner? Everyone is a copyright owner. Once you create an original work and fix it, like taking a photograph, writing a poem or blog, or recording a new song, you are the author and the owner. Companies, organizations, and other people besides the work's creator can also be copyright owners. Copyright law allows ownership through works made for hire, which establishes that works created by an employee within the scope of employment are owned by the employer. The work made for hire doctrine also applies to certain independent contractor relationships for certain types of commission works. Copyright ownership can also come from contracts like assignments or from other types of transfers like wills and bequests. Or bequests? Or bequests, okay. All right. Okay, that's kind of cool. Yeah, and I mean, like, work for hire means, like, let's say this is what I think it means, is like, let's say I get an employee that works for me and, like, draws cactus, like I draw cactus, then I guess like his cactus or my cactus. I don't know. I mean, I think that might be how it works, but uh, I I don't know. I'll figure that out later. What rights does copyright provide? U.S. copyright law provides copyright owners with the following exclusive rights: reproduce the work in copies or phonorecords, prepare derivative works based upon the work, distribute copies or phonorecords of the work to the public by sale or other transfer of ownership, or by rental, lease, or lending. Perform the work publicly if it is a literary, musical, dramatic, or choreographic work, a pantomime or a motion picture or other audiovisual work. Display the work publicly if it is a literary, musical, dramatic, or choreographic work, a pantomime, or a pictorial, graphic, or sculptural work. This right also applies to the individual images of a motion picture or other audiovisual work. Perform the work publicly by means of a digital audio transmission if the work is a sound recording. Copyright also provides the owner of a copyright the right to authorize others to exercise these exclusive rights, subject to certain statutory limitations. Okay. Statutory limitations. Not 100% sure what that means, but it's probably like a contract, like, hey, you can use this cat picture for like 3 months to do something, and then after that you gotta stop or something, I think. Yeah, if there's any lawyers that watch this video, definitely comment. That would be cool. 'Cause, just kind of going through this for the first time. And let's see. Yeah, phono records, that kind of seems like it was like made in the like 1920s phono record, like something like Alexander Graham Bell or something like was like, oh, it's a phono record. Okay. Pantomime. But yeah, this is all good stuff. So these are your rights. So, when you complain about, having to pay, to listen to music or to that you can't play a copyrighted song on your YouTube video, just remember that like maybe one day you'll create something cool and you'll have all these rights, and you don't want people to, you know, mess with your stuff, because you took all that time and effort to make it. So, you should get at least something for it, I think. But, you know, up to you, whatever. But just saying. Um, but I'm not, I've definitely, uh, you know, gone back and forth on like, my understanding of this, but I try and, just have that respect in mind, but I get it, there's a lot more complexity that goes along with this, and then ownership, and there's all kinds of weird stuff. So I'm not going to go into that, but yeah, if you're interested in copywriting things, it helps to have that like internalization of like your own interaction with copyrighted material. So okay, let's go. How long does copyright protection last? Okay, so this is like the Mickey Mouse thing. The length of a copyright protection depends on when a work was created. Under the current law, works created on or after January 1, 1978 have a copyright term of life of the author plus 70 years after the author's death. If the work is a joint work, the term lasts for 70 years after the last surviving author's death. Last surviving author's death. Maybe that's how Mickey Mouse survives. For works made for hire and anonymous or wow, don't make fun of me. Pseudonymous works, copyright protection is 95 years from publication or 120 years from creation, whichever is shorter. Works created before 1978 have a different time frame. Learn more about copyright duration in our Duration of Copyrights circular. Okay. Yeah, so I'm not gonna like pretend to know more than what's written here about this, but I'm sure there's like case studies and different things, but like if you think of like Disney, right? Like when did Walt Disney die? Let me look that up. Uh, Walt Disney life. Wikipedia. Died 1966. I don't know. Why am I looking at Walt Disney? This was copyright term. Life of the author plus 7 years after the author's death. That's 70. What is 1996 plus 70? Okay, yeah, that's 70. 19 or what, 2036? Is that what that would be? 1990. Judge me. Let's see. 19. Oops. 1966 plus 70. 2036. Okay. 2036. Life plus 7 years. Have copyright term life current law on or after 1960. Okay. If it's a joint birth 7 years after the last surviving author's death. Okay, so they're probably using some like legal kung fu, but they're also a giant corporation, so um, they probably have the money to do legal kung fu or legal, whatever style of martial art. Um, okay. Yeah, I spent a lot of time on that one. When can I use works that are not mine? Agreements, exceptions, and limitations. It is important to know that we are all also copyright users. When we read books, watch movies, listen to music, or use video games or software, we are using copyright protected works. So even if you are not the owner of a work, you still may be able to use it, in addition to buying or licensing works, or some other way of seeking permission to use the work. You can also use one of the Copyright Act's exceptions and limitations, or rely on works in the public domain. The Copyright Act's exceptions and limitations found in sections 107 through 122 include fair use, the first sale doctrine, some reproductions by libraries and archives, certain performances and displays, broadcast programming transmissions by cable and satellite, to name a few. Interested in more information on fair use? Take a look at the Fair Use Index. The complete list of exceptions to copyright protection can be found in Chapter 1 of Title 17 of the United States Code. Okay, there it is. You can also use works that are in the public domain. Works in the public domain are those that are never protected by copyright, like facts or discoveries, are works whose term of protection has ended either because it expired or the owner did not satisfy a previously required formality. Currently, all pre-1926 U.S. works are in the public domain because copyright protection has expired for those works. Okay, cool. So yeah, public domain, that's pretty cool. That stuff goes back into the mix. But yeah, something that's like kind of interesting, like with this stuff, is and maybe I'll bump this up so you guys can see it better. Yeah, that maybe it's a little easier to read there. But yeah, I'm wondering, so like, let's say you're like a graffiti artist and you spray paint a really cool character or something on the wall, and then everyone takes a picture of it because it's so cool. And then later, as a graffiti artist, you go back and you're like, wait a second, like that's my art, like you gotta pay me or whatever. And then people are like, but yeah, it's graffiti. You put it in the public domain because you sprayed it on, like my wall. Like, do you still have the right under copyright to own that character? I'd be curious to know that, like if anyone has a comment or any sort of thoughts on that, because I think that's like kind of interesting, because like graffiti, when you do it in the street, like the street is for the public, right? So like, is graffiti always in the public domain? I don't know. I'm not like a true graffiti artist. and I'm not a lawyer. But I don't know. I'd be interested if anyone has thoughts or knows the answer to that. Um, okay, let's keep it going. What is copyright registration? Copyright exists automatically in an original work of authorship once it is fixed. There's that fixed word again. But a copyright owner can take steps to enhance the protections. The most important step is registering the work. Registering a work is not mandatory, but for U.S. works, registration or refusal is necessary to enforce the exclusive rights of copyright through litigation. Timely registration also allows copyright owners to seek certain types of monetary damages and attorney fees if there is a lawsuit, and also provide a presumption that information on the registration certificate is correct. Copyright registration also provides value to the public overall. It facilitates the licensing marketplace by allowing people to find copyright ownership information, and it provides the public with notice that someone is claiming copyright protection. It also provides a record of this nation's creativity. That's cool. Bragging rights. There is only one place to register claims to copyright in the United States, the Copyright Office. For more information on registration, benefits, and procedures, please see our copyright registration circular. Oh, this is kind of cool, So I was watching this like documentary called The Sound of Music, and it's like a 1974 doc on like synthesizers and all these like different musical instruments, like the Moog. What is it called? The Moog first one. Moog one. What is Moog one? Moog, the Moog one. It's oh shit. Never mind. Synthesizers. But anyway, magnetic tape recorders. Um, so I the document or the documentary is called uh The New Sound of Music, and that's 1974. But there's another documentary or series. It's called like Mark Ronson. What is it? Mark Ronson music doc. What is that? Watch the Sound. Yeah, that's a cool one too. That goes over the different instruments and plugins and cool things. Which he has a pack on GarageBand that's pretty sick. You should check out. But anyway, yeah. So it, in that 1974 doc, they talked about how American GIs, um, returning from World War II, um, discovered that the Nazis had been using magnetic tape recorders, or they were using this like plasticky type of film with like this metal attached to it, and they were able to kind of like record music or record for whatever Nazi activities they were doing during World War II. And the American GIs, I think, like took that and then came back to the United States and like either made their own tape recorders or what's it called? Uh, made their own technologies or whatever that were taken from, I guess, the Germans. And then they, I guess, patented it or copyrighted it. I don't know. But it's interesting because, like, I wonder, like, like, let's say that, like, this guy made a character, like, in, like, Mexico, and I saw that character and I, like, made a sketch of it, and then I came to the US and copyrighted it. Would the US Copyright Office do like an international due diligence to make sure that I didn't steal it from like an international person, or is that like the UN, or who would be like uh who would be responsible for that? Um, is my thing because like I mean I don't think we're gonna go over and enforce it in another country and vice versa. I mean, I guess you could out someone like on social media, or you can out someone publicly, like be like, hey, yo, this dude stole my shit. And it's, I guess at that point, it's whoever has the most evidence. I'm not sure how international copyright stuff works, but yeah, I just wonder if the US really cares to enforce a copyright if you've infringed it from another country. Not 100% sure on that one. But okay, let's continue on. What about other intellectual property rights? Patent and trademark are other types of intellectual property that may cover works and are considered separately from copyright eligibility. For example, patents which are granted by the government protect certain inventions or discoveries, designs for articles of manufacture, and plant varietals. Trademark law, on the other hand, protects words, names, symbols, or devices used in trade with goods or services to indicate the source of the goods and to distinguish them from the goods or services of others. For more information on these other types of intellectual property, take a look at the United States Patent and Trademarks Offices, or sorry, take a look at the United States Patent and Trademark Office's patent and trademark information. Okay, cool. I might check that out later. Maybe I could do patents and trademarks in another video. Um, okay, but cool. Yeah, this kind of makes sense about intellectual property rights because, like, let's say, you want to buy diapers from like Huggies, right? And uh, another person is trying to use the same name, but maybe their quality is bad, or maybe they have like arsenic or some shit like in their product. I don't know. And like you're like you want to make sure you buy the one that doesn't have arsenic in it, ideally, unless you're into that thing. Okay, that makes sense. Moving on. What if there is a change in ownership? Let's see, look at our time. Okay, 6 minutes. Document recordation. The Copyright Office also records documents related to copyright. This is known as recordation. That means the office reviews and accepts documents and keeps a record of the documents people provide. Recordation relates to three different kinds of documents: transfers of copyright ownership, other documents relating to a copyright, and notices of termination, which authors or their heirs use when terminating certain transfers or licenses. Okay, cool. I'm sure, I guess, if you can sell a copyright, I'm not sure how that would work, but I'm sure this is what that is referring to. What is statutory licensing? Okay, cool. So we saw that. Where did we see statutory? Yeah, right here. Oh, that's limitations. Never mind. I got that confused. What is statutory licensing? Statutory licenses are some of the limitations in the Copyright Act. They relate to certain uses of musical compositions, sound recordings, and cable and satellite programming. For comprehensive information on musical compositions and sound recordings, we have a number of useful resources like our circulars and or our dedicated Music Modernization Act page. For information on cable and satellite uses, visit our licensing division page. Okay, very cool. Oh, and also here, I may check this out, but or actually I will probably check this out. For more general information on copyright law, please see our Learning Engine video series. You can learn about registering your copyright claims, including about some of our applications for a few common types of works on our Engage Your Creativity page. If you want more detailed information on copyright law, we invite you to read our circulars, our FAQs. For a more advanced guide, please use our Compendium of U.S. Copyright Office Practices, 3rd edition. The compendium is the office's administrative manual relating to the Copyright Act and our regulations and practices. It provides instruction to agency staff regarding their statutory duties and provides expert guidance to copyright applicants, practitioners, scholars, the courts, and members of the general public regarding institutional practices and related principles of law. We're here to help. The Copyright Office website, copyright.gov, is the definitive source of copyright information. If you need additional assistance, the Public Information Office is available to help. You can contact us online, 202-707-3000 or 1-877-476-0778, or visit the office in Washington, D.C. Oh, maybe I should walk over there. Let me sick. Um, in the Library of Congress, Madison Building. Staff is available Monday through Friday, 8:35, except on federal holidays, as they should. Want to learn more about the Copyright Office and what we do? Visit our overview page, where you can discover how we have been helping the public since 1870. Very cool. Okay, but yeah, so here we go. So back to the beginning. So before you spend money to using software or using buying people's guides for copywriting or ebooks or whatever, remember that the Copyright Office is a created by the public for the public and is the quote definitive source of copyright information for free. So I'm not trying to plug the U.S. Copyright Office. They obviously don't pay me anything or couldn't pay me anything, I don't think, even if they wanted to. So I'm advertising something that's free. So if you want to learn more, learn it from copyright.gov because I'm sure there's plenty of people that would, steer you in a direction just to kind of make a buck off you because you don't know you either don't know about it or you don't know enough about it. And I don't know about it, so that's why I'm learning about it. So here we are. Let's see, you got 2 minutes. But yeah, so this is the source, like this whole website, copyright.gov, and all the resources they have. This is how you learn. And you're getting it, straight from the source. So if there's, outside of maybe having an attorney help you and the business stuff, this is kind of where you can learn. Um, but yeah, so just let me recap really quick with the last time I have, or the last bit of time I have. So I set out to uh, kind of learn about what copyright is in the United States at like a base level. Um, and we learned that it is protective of your original works of authorship, um, how the work is fixed, whether it's drawn, printed, spoken, whatever, and the ins and outs of like what those expressions can be, ownership, um, what rights you have, how long it lasts, what's not yours, registration, intellectual property or IP rights, changes in ownership and licensing. But it's at a high level, so I definitely don't have all the tools I need to copyright something right now, but I think I'll pursue it and look into it, and I definitely think I have a lot of creative things and ideas and things that I've made that are worth maybe protecting. I don't know. Um, but yeah, I mean, learn about it, and if you make cool stuff, you should definitely know about it at least at a base level, like a non-zero level. You should know about it, and also too, I mean, if you are creative and you're making stuff, as you go about your day-to-day life, we all use so much creative works and copyrighted stuff. It's just helpful to, I guess, give a respect to the artist and give a respect to the person who used part of their life creating this work that we all enjoy. So I definitely want to give people credit where I can, and I definitely want to, if I don't have the money, at least show support in some form. But yeah, the whatever happened in 1870 to make it so that we should have a copyright office or a public service to protect our intellectual rights or whatever. Some shit went down in 1870. I'm sure that's why this law exists. Most of the time, laws exist because some shit went down. But yeah, I mean, because of it, we can kind of do all this stuff, and for better or worse, this is kind of how we go about it in the United States. So yeah. So that's me. I bullshitted about U.S. copyright law. Um, so yeah, go out there and make some cool stuff. And if you do make some cool stuff, tag me so I can check it out, you know. And if I steal it, sue me. Um, actually, don't, um, because I'm not gonna steal your stuff. But if I did, you could sue me, and you would be covered under, I guess, this. So yeah. Um, but yeah, you know, and I think there's one thing. This is my last piece I'm gonna say. Is there's like a lot of stuff you'll see online. It's like good artists. What is this? Artists steal. What is that? Yeah. Do good artists copy and great artists steal? What is that? Good artists steal. The famous quote is often attributed to Pablo Picasso. It reflects the idea that creativity and inspiration often come from borrowing and reinterpreting existing ideas. Picasso himself was known for drawing inspiration from various sources, including other artists, cultures, and historical works. In the world of art, the act of stealing, quotes, can refer to adapting, remixing, or incorporating elements from different sources to create something new and unique. Whether it's in visual arts, musical, literature, or other creative field, artists often build upon what came before them. They take inspiration from their predecessors, transform it, and add their own perspective. The process of borrowing, adapting, and innovating is essential for artistic evolution. So, next time you encounter a work of art that resonates with you, remember that it might be the result of a talented artist who skillfully, quote, stole from the vast tapestry of human creativity. And this was from Microsoft's Copilot AI assistant. So that AI assistant essentially stole this whatever from the internet. So I guess like long story short, um, I guess if you borrow or draw inspiration, make it original as much as you can, you know? Like if I were to like fuck, what is it? Let's see, paint. Like, where's this Microsoft Paint? How do I paint? Yeah, yeah. Here we go. Okay, let's see. Just for shits and giggles. Where's it? Right there. Now I need like a thicker brush. What is that? Like a oil brush or some shit? No. Where am I going? What am I doing? What am I doing? Okay, here we go. Yeah, like I guess like let's say I'm gonna Pablo Picasso this Microsoft Copilot logo. Let me go to colors. Can I picker, pick a color? Where's the dropper tool? Oh, dropper. I guess I can't do that. Okay, well, yeah, like, let's say I was gonna steal their freaking weird logo. Nope, yeah, there we go. Yeah, nope. Wow, I completely screwed myself. Do I not know how to use paint anymore? What have I done? What am I doing? Yeah, we're just gonna start over here. Okay, I'm really off the rails here. Um, yeah, but let's say I was gonna steal Microsoft's little logo. I guess like me saying I'm stealing it is like evidence that might be used in court, I guess. So maybe I couldn't do this, but yeah, I guess whatever. Is this thing? It kind of looks like, was that Copilot? Yeah, yeah. So this looks shitty enough that I could probably call it mine. So, you know, I could what's it called? Be like, "Hey, I have an AI tool called, you know, Steve says things to you." And then I could have this as my logo. And then Microsoft would be like, "Hey, like that kind of looks like our logo. We're gonna sue you because we have like a copyright or some sort of thing. And then I would be like, hey, but like, look at mine. Mine like looks like oh shit. Yep. Well, that was canceled. Yeah, but they'd be like, hey, your logo kind of looks like my logo. We're gonna sue you. And I'd be like, well, but mine's like really shitty looking. And they'd be like, well, yeah, but it's kind of like the same colors. And then I'd be like, okay, I don't have enough money to, go to court or jail. So yeah, I'll change it. I'll make it brown or some shit. Yeah, it's brown now, So like, I feel like I get it, like I get the whole good artists steal or whatever, but I think it's just this whole thing is the vast tapestry of human creativity. I think like, as you create, depending on like what you're trying to do, and I mean if you're just trying to make money, you're gonna like protect everything you make and everything you touch, because you just want to make a buck off of every part of it. But also in the same token, you might like want to, you know, um, you put a lot of work and you put a lot of effort in, you might want to, just get paid back for all that time you spent, right? Because time is your most valuable resource, right? But at the same time, when you create something and it's out in the world, um, it's out in the world and people can do everything to it, for it, whatever. So, it's important to both protect your stuff, but also, it's important to protect, but in my opinion, it is also important to to share as well, So like if you are doing great or whatever and you are just interested in, maybe you had success with the design, but you're ready to move on to something new, or maybe you've been creatively fixated on this one thing and you're ready to let your bird go free or, uh, whatever saying or whatever. But, once you're ready, I mean, I think there's a way to like sunset something by putting it into the public domain. I probably use sunset in the wrong way, but I don't know. And I'm way over. Oh shit. I'm way over time. But yeah, I guess just like maybe consider that, you know, although protecting stuff is great, um, protecting every little thing, I mean, may or may not be what's best for um, the creative community in general. I don't know. That's all I'm saying. Because there's a lot of people that, have opinions on things like, whether it's, drugs or generic things or, you know, engineering designs that could help people that maybe are poor or, wouldn't have had that because they couldn't have paid because it was protected or whatever. I don't know. Just it's just something to think about. I'm rambling, but again, this is called BSing with Steve, so I'm just BSing at you. Um, but okay, cool. I'm gonna stop. But you guys, or you people, you everyone, humans, just have fun, create some stuff. Check out the U.S. copyright website. If you make something cool, copyright it. And then when you're old and rich, maybe consider putting it into the public domain. I don't know, might be fun. But okay, create some fun stuff. I look forward to seeing it. If you do share it, whatever you make is beautiful because you made it. So just keep that in mind. And yeah, have a great day. Have a great rest of your week. And I wish you just the most success in whatever you do. All right. Thank you.